All right, video 7, King's Prerogative. This is going to be a two-part, maybe possibly a three-part. We'll find out where this leads, but definitely it's going to be a two-part video series on this one topic. I'm going to begin from the book titled The Law of Nations, or the Principles of Natural Law, book 1, chapter 1, by Emrich de Vattel, entitled Of Nations, or titled Of Nations or Sovereign States. Reading from subsection 1, of the state and of sovereignty, it reads, a nation or a state is, as has been said at the beginning of this work, a body politic or a society of men united together for the purpose of promoting their mutual safety and the advantage of their combined strength. And from the very design, that induces a number of men to form a society which has its common interest and which is to act in concert. It is necessary that there should be established a public authority to order and direct what is to be done by each in relation to the end of the association. This political authority is the sovereignty, and he or they are invested with it are the sovereign. He continues on in the same chapter, subsection 3, titled Of the Several Kinds of Government, states, if the body of a nation keep in its own hands the empire or the right to command, it is a popular government, a democracy. If it entrusts it to a certain number of citizens, to a senate, it establishes an aristocratic republic. Finally, if it confide the government to a single person, the state becomes a monarch, and that's what we're interested in discussing. Now, this is where we begin the video to speak about that single person, originating immediately after post-AD 1066, whereby the fate of this new form of governance rests in the hand of a king and successors. Today, Crown R holds radical title to all the states and land. Crown R, as discussed in video, I think it was video 2 of this English law series, is representative of a direct link to the life estate held in possession of or expectancy, and of expectancy, there are two sorts, either reversion or remainder. Now, for those who've gone through the original series, hey, kudos to you. That's a tough one. I'll spend briefly on remainder reversion just as a refresher, but for those who are just new to this channel, I'll just give a little bit of overview, reversion, remainder, so you can get a little bit of a touch upon where we're heading and what we're always going to be speaking about, okay? In order to, reach our final goal, which is to look at vesting our estate, our life estate, through settlement of the trust. Now, concerning the three types of estate interest held in common law, now as I expand about reversion remainder as equitable interest, which we had briefly touched upon in the opening videos of this series, namely those identified as either a fee simple, fee tail, or a life estate. Now, I'll take a moment to introduce these distinctions. The fee tail has the potentiality to transfer the estate and land by means of reversion or remainder, such as an issue extinct, meaning no blood heirs. So without a grantee, by means of inheritance, this estate can now be transferred by either rule, remainder or reversion. The life estate, after determination of possession is made, is transferred by either of the two sorts. This happens in all cases after life ends, so the life determinable has ceased to exist, whether it's natural or civil, natural civil death, or a condition precedent or subsequent has been realized. The point is, in either case, in all of these cases, whether it's life or it's conditions precedent or subsequent, it's always going to be determined through the rules of expectancy, of those possessions in expectancy. And the fee simple has the minimalist ability to transfer the estate land in either acts of reversion or remainder, since the fee simple, as described by Blackstone and Laskin, and to quote Boral Laskin entirely in chapter 3 of his book, Cases and Notes on Land Law, he opens chapter 3 with, the largest or highest of the feudal estates is the fee simple, unquote, which always represents the entirety of the state's interest, and this there is no remainder, as it is not a residual of an estate left over after its determination, and so rather the transfer of the entire estate is hinged upon it be complete, so not a residual, so identifying it as a fee simple interest. An example of reversion concerning a fee simple estate, this estate would include, for instance, a condition subsequent annexed to the estate, so a condition attached to the fee simple. Why it is necessary to first create a life estate, I suspect, for the reason that we need to gain entry into the rights offered under English law of land tenure, which is represented through an initial life estate, not a fee simple. Since more often than not, the life estate is created by an act of law versus an act of parties, which is the latter is most often the feature of a fee simple. So, conclude this thought, it is evident that we are infant, initially, of course. We have no ability to contract for lack of mutuality or understand trust rules, and this being set in reason, being that the life estate is an equitable interest, so thus a separate interest from a legal title, it is through operational law, it moves our benefit into a trust, among other matters, but this is not the topic of this video, and so I'll return to the topic. The king, aka Crown R, exists at the apex, irrespective of whether a body of men form a republic or democracy, since all land must rest somewhere. And as before indicated, the English law is the evolution of the feudal land tenure system, which is a hierarchical system of landholding. Every piece of land is held by a superior. We as individuals cannot be forced into any singular agreement belonging to a group, and this why the law is perfected by joining us as an individual to Crown R through operation of law, on an act of parties, in which the group's proviso must be, well, just stated, through an act of parties, i.e. must be able to determine an express or implied agreement in order to effect an authority through a type of jurisdiction which secures this agreement. William Blackstone, an English jurist and legal scholar of the late 18th century, who was commissioned to write the complete understanding of English law under the scrutiny of minds alike for the time up until the 18th century, explains the powers of a king, and it's through the law first that recognizes this power. So law before king, of course. It was said that those who came to settle in the Americas, and it's also good here to add, the colonists came with two books essentially that were paramount to creating settlements within the colony, and that was the Bible and the Blackstone's commentaries. Now, every subject brought with them so much as the law was pertaining to the matters that were happening at the point of the colony. So, for instance, if a colony was established sometime later than 1688, well, we don't care about tenures and the abolition of tenures, which began in 1660, because everything's moved in free and common socket. So we'd be moving and only dealing interest in English law under free and common socket. So that would pertain to all the colonists, at that time. That's the law that would bring in, and that's why they would have the book like with Blackstone's commentaries, and then in order to make sure that they describe and stay in alignment with the laws that have evolved through the feudal land tenure system. In Book 1, Chapter 3 of the King and his title, we get an overview of those powers and duties of a king. William Blackstone addresses the title of monarch being either, and this is a quote from the book, male or female, and is vested immediately with all the ensigns, rights, and prerogatives of sovereign power as is declared by Statute 1 Mar St3C.1. Now, for those who are new to this type of encoding, it is best we learn how to interpret what is called a Roughhead statute, which was introduced by Owen Roughhead in the period of 1663 to 65, who wrote a significant piece of literary work by identifying and cataloging all English statutes. His work, titled The Statutes at Large, was coincidentally completed at the same time William Blackstone introduced Book 1 of his commentaries. So to decode this Roughhead statute, that being 1 Mar St3C.1, it would be interpreted as follows. 1 Mar refers to the first year of the reign of Queen Mary I of England. St.3 indicates the third session of Parliament held during her reign, and C.1 refers to Chapter 1 of the statutes passed in this session. So Queen Mary first began her reign in July 1553. The statute in question was enacted during the third session of Parliament, ST3, under her reign, and met from October 11th, 1555 to December 9th, 1555. Thus, the statute likely dates to 1555. Well, it looks like here we are. We're at 10 minutes. Perfect. We're getting to extend, I don't want to go past any further past this video. We'll go into part 2, and we will just deal with that matter of the King's prerogative. And I think what I'm going to do is just have an overview done through AI or ChatGPT 4.0 to then bring that complete, what the complete idea of prerogative is based on the full synopsis and summarization of that chapter. So hope if you enjoyed the video, thanks for joining. And if you've learned anything here today, hey, press the like button or tell me what you really think, which, it's good either way. Thank you for listening. Best wishes.